Hello, everybody. I'm George from Ireland. This is my English law channel. So this is about homicide. So we're in criminal law. Hope you like the bad taste. Jumper might inspire homicide in some of you. So homicide is killing a human being, and in England, Wales, that's killing a human being outside the womb. Killing an embryo or a fetus is not a crime usually. Towards the end of a pregnancy, it could be a crime if it wasn't authorized under the exceptions in the Abortion Act. But even then, if it was illegal under the Abortion Act, it still wouldn't actually be homicide. But might come on to that a bit later. So killing humans even outside the womb isn't always illegal. There are times when it's permitted, and we'll look at the justifications, such as self-defense, a little bit later. So we're looking at criminal homicide. When it's a crime, it could be murder, could be manslaughter. So there are various types of manslaughter. We'll come onto the categories. There's involuntary manslaughter, and under involuntary manslaughter, we've got three subcategories: reckless manslaughter, gross negligence manslaughter, or constructive manslaughter. Coming on to voluntary manslaughter, well, this could be due to a temporary loss of self-control, could be diminished responsibility, or it could be a suicide pact, folie à deux, where one of them manages to commit suicide and the other fails. Okay, so in order for it to be either murder or manslaughter, a human being has to be killed. So anyway, if killing someone is completely accidental, it might not be that the person who kills another is culpable. So note that consent is no defense to killing a human being, even if you kill someone with that person's consent, with that person's express request, and there's absolutely no doubt about that. That's still against the law in the United Kingdom. The UK doesn't permit euthanasia, and so there are some people terminally ill in most extremist agony who want to go to the Dignitas clinic in Switzerland to have their lives ended. They may be paralyzed, unable to take a pill, administer an injection to themselves, and if you push your loved one onto the plane by the wheelchair onto the plane, then you could be facing a murder charge. Anyway, so let me see. So dueling in the old days, that wasn't allowed either. Even though you both consent to try and kill each other, that still counted as murder. So there was the case of Nicholson, 2014, coming back to mercy killings. He suffered locked-in syndrome, wasn't able to move, and so he wanted to end his life. So anyway, he said his life was simply unbearable. But that was still regarded as being unlawful. So it was Nicholson and the United Kingdom. It was a case which went to the European Court of Human Rights in 2015. Anyway, it was found that it was still unlawful. So the House of Lords was asked to address this. Are you going to grant an exemption? These mercy killings in these cases, where the person's an adult of sound mind, has an incurable illness, certainly wishes to die, affirms that multiple times in the presence of witnesses, solicitors, so on. And the House of Lords said, we're not going to authorise that. Forgive me, the Supreme Court said we're not going to authorise that. That is too tendentious. That's a matter for Parliament to address. It'd be wrong for us to assume the legislative role in this respect. So there was a similar case called Carter against Canada Attorney General in Canada in 2015. So anyway, Canada found it was against their fundamental charter of rights and freedoms. I don't know if they've actually legalised it at the Canadian Parliament. So anyway, criminal law in the United Kingdom recognises an individual's right to control his or her own body, but not to the extent of getting another to kill them. Incidentally, if you kill yourself, that's not a crime. We can't prosecute those who are already dead because they committed suicide. If you attempt to commit suicide and fail, that's not a crime. Until the 60s, it was, bizarrely, attempting suicide. There was a book called Suicide in the Middle Ages by a historian called Sandy Murray, taught me, lucky chap. And in medieval Hungary, attempting suicide was punishable by death. Certain illogic to that, but I suppose the would-be suicides are perhaps satisfied with the outcome. Oh my goodness. Anyway, so remember that an adult of sound mind usually has the right to refuse medical treatment, even life-saving medical treatment. there was this case where there's this pregnant woman and there was something going wrong with the birth, and if she didn't have a cesarean section, then she was likely to die. So the doctors performed on her against her will. Nevertheless, this was held to be unlawful. That was St George's Healthcare Trust, NHS against S, a 1999 case. So adults have a right to make what many would regard to be foolish decisions ending in their own death. Incidentally, saving the infant's life, that was neither here nor there, because if the doctors hadn't done that, not only would the woman have died, her baby almost certainly would have done as well. So incidentally, homicide can only be committed against Homo sapiens. Killing another's animal is often illegal, but it's never homicide. Okay, well, let's look at, of course, at everybody's favourite topic, murder. Nice, juicy one. So the actus reus here is intentionally killing a human being or intentionally causing grievous bodily harm, which ends in death. If you didn't wish to actually kill the person, you wish to cause them serious physical harm, but that actually ended up killing the person, that's still murder. So obviously there's the mens rea, there's the guilty mind which accompanies that. So there is some malice aforethought, as in you thought about it in advance. Anyway, so let me see. It's if a mercy killing is still unlawful. And remember, there was Inglis, a case in 2011, where there was this man who was in a persistent vegetative state. He was in a bed, he couldn't move, couldn't do anything, and the mother decided to give him a fatal dose of heroin. She thought this was an act of compassion. Nonetheless, that was murder, and there's this compulsory life sentence for it. Might seem ridiculous. The Liberal Democrats, as long as 2001, wanted to remove the compulsory life sentence for murder. You could get a lesser sentence for murder in these special situations. Now, sentencing is a whole other ball game, but life sentences virtually never mean life. They're almost always let out, even if it's after 35 years. If they're terminally ill, they usually get benevolent parole for the last few months. If they're estimated to have under 3 months to live, they're usually let out. But the sentencing is not, strictly speaking, within the purview of this course. So intention, well, what is that? We know intend, I wish to do it, I want to achieve a certain outcome. That's intend. So the judge has to direct the jury about when they could find an intention or they must find an intention under certain circumstances. There's a direct intention where, yes, the defendant definitely wanted to kill the victim, absolutely clear about that, might even admit that in open court. Other cases, it's not quite so straightforward. And remember, if you intended, as in you desired, to cause the person grievous bodily harm, but that grievous bodily harm actually ended up killing the person, that is still murder. So anyway, there's also this indirect intention, which is more oblique, but I'll come on to that a bit later. So anyway, there's this mens rea for murder. We know that they want, in the person's mind, the defendant's mind, is the wish to end up killing the victim. So if for example, a criminal stabs somebody else through a fight, then that's murder, right? Now, the killer might say this was an accident, but nevertheless, you stabbed the person, even if you didn't wish to kill the person. You knew that death was a considerable likelihood, therefore it's murder. Okay, so let me see. Supposing you throw somebody off a building to give them a fright, to warn the person that the person dies, well, that's still murder. Oh, I only wanted to give him a fright. Well, come on, you know that's very dangerous. That can be murder, even if the defendant was telling the truth. Even if we could be convinced he genuinely actually didn't want to kill the person, nevertheless, it would be murder. So there was in Wool in 1999, Lord Steyne had to give a ruling on a similar case, and here's what he had to say about it. You've been told it was not the defendant's intention in throwing the victim off the roof to kill him or cause him a serious injury, but just simply to teach him a lesson. You are entitled to disbelieve this. But if you think this claim may be true, I must direct you may still find the necessary intention if you're convinced that, whatever else the defendant intended, he knew at least one of those consequences would almost certainly occur. Okay, end of quotation, as in the defendant knew that either the victim would die or would suffer grievous bodily harm. If you believe that the defendant knew that the victim would die or there was a considerable chance he'd suffer grievous bodily harm, you can still convict of murder. So anyway, let me see. So we have to impute to the defendant that he knew that one of these things would probably happen as a result. If you think there's only a slight possibility, then that could still be manslaughter rather than murder, having thrown him off the roof, not actually want to end up killing somebody. Anyway, so we have to try and work out what is intended in many cases. So there's this intention to kill or intention to cause grievous bodily harm. Or there was a case called Cunningham in 1982 where the defendant hit somebody over the head with a chair, and that resulted in death. So he was found guilty of murder. Well, Cunningham launched an appeal, and he said that he didn't intend to kill, therefore he's not guilty of murder. But no, the court said, so what? You're still guilty of murder. There was a similar case called Vickers, where somebody did something intended to cause an injury, which actually ended in death, and Vickers was nevertheless convicted of murder in that case. The case about throwing somebody off the roof is called Woolen, as in that's the name of the defendant. It was R against Woolen, as in the Crown against Woolen. R standing for Regina, the Latin for Queen. Okay, so there are many examples to look at. So many people are unhappy with the law on murder, because of this mandatory life sentence, which I talked about. So a sadistic psychopath who goes on these killing sprees just for a thrill, he is getting a life sentence, as well as somebody, this loving wife or husband who kills his or her spouse in order to spare the person avoidable agony. They're put into the same boat. You might say that's deeply wrong. Okay, so there was the Powell and Daniels case, 1999. We'll come on to that a bit later about what is unclear who actually carried out the killing. Now let's look at voluntary manslaughter. So that's killing somebody. So the prosecution can demonstrate the defendant intentionally killed someone or almost intentionally did so, but there's something mitigates this to make it less than murder. So there are two main defences. One of these are loss of control, and the others are diminished responsibility, which reduces the degree of culpability to manslaughter, from murder down to manslaughter. So if you're severely provoked, so there's both a subjective and an objective part of that. Subjective, what the defendant feels, what's in my heart, in my mind, as the objective, what a reasonable person would feel in that situation. So the provocation could be that the victim said or did something which was so heinously offensive that the defendant lost control of himself and then killed that person. Okay, so this loss of self-control means that it can't be to do something seeking vengeance. It can't be anything where there was a premeditation to this crime, like that. Ibrams in 1982 is an example of that. If there's a long time lapse between the provocation and the slaying, then this could still be manslaughter. Duffy, 1949, is a case like that, or Ahluwalia, 1992. So Mrs. Ahluwalia, she was a British Indian woman. She was in an abusive marriage, severely beaten up by her husband for a long time, and eventually she lost it, and she put a fatal dose of, I think, sleeping pills into his food, which caused him to die. Feminists took up her case. She was facing a murder charge, but anyway, it got off with voluntary manslaughter on the grounds of provocation. She had driven him to it. It was a slow burn sort of thing, because the prosecution say, well, if she really lost her self-control, why didn't she kill him the moment he first beat her up, when he's doing this all the time, and eventually she snapped. It was the final straw, and she couldn't take it anymore. Looking back on Ellis, 1954, the last woman to be hanged in the United Kingdom, Ruth Ellis. Some people say it was something similar looking back on it. She was in an abusive relationship, beaten up by her unfaithful boyfriend, who pressurised and having an abortion, which was illegal, and then found out he was carrying on another woman, went to a pub and shot him dead in front of several witnesses, and stayed there almost dazed, stunned, to the police to turn up, made no attempt to escape, frankly confessed her guilt from the very first moment. And looking back in it, some people think it was sort of post-traumatic stress disorder from the way she was beaten up by her boyfriend. Anyway, so in order for provocation for this defence to operate, the things said by the victim or the things done by the victim must be extraordinarily provocative, so grossly insulting that it would cause an ordinary person to lose his or her self-control, taking into account the race, the gender, the body type of that person. So, I mean, if it's a very, very strong man losing his self-control against a very weak man, you see, that's less convincing because he knows he can beat him up easily. But if it's a very small, skinny, weedy guy losing it with a very muscular man, well, that's more believable because you wouldn't attack someone who's physically far stronger than you unless you'd really lost the cool. Okay, so a woman losing it with a man is more convincing, as women are usually less physically strong. Race comes into it. If someone's race was foully insulted, it might cause him or her to lose it, things like that. Now, if your self-control has been reduced because you've voluntarily imbibed alcohol or something, then this defense won't operate. There are they don't make allowances for mental illness. That's different. I mean, you could be not guilty by reason of insanity and going to a psychiatric hospital for the rest of your life. That's not going to help you. If you are a person with an explosive temper, no, that's not going to work. We're going to look at what an ordinary person would feel like in this situation. People are very volatile. No, we don't make special allowances for them. Okay, so the Coroners and Justice Act 2009 allows this defense of self-control, and it says what the qualifying triggers can be: the words or actions which are so outrageously insulting it would cause a normal person to simply lose the cool and do heavy violence to another. So it can't be because you're annoyed because a baby was bawling, because your girlfriend or boyfriend was just irritating. It can't be because of sexual infidelity. The sexual infidelity or the honor killing excuse, that is specifically excluded. Okay, so Section 54 of the Coroners and Justice Act 2009 says, where a person, defendant, kills or is party to the killing of another victim, D is not to be convicted of murder if the defendant's acts and omissions in doing or being party to the killing resulted from the defendant's loss of self-control. The loss of self-control had a qualifying trigger. A person, the defendant's sex and age, with a normal degree of tolerance and self-restraint in the circumstances of the defendant, might have reacted in the same way or a similar way to the defendant. For the purpose of this subsection, it does not matter whether the loss of self-control was sudden. End of quotation. So it doesn't matter whether it was sudden or it was much later, as in Ahluwalia. It's after years of abuse. I mean, the moment when she put the fatal dose of sleeping tablets into his food, I think he'd beaten her up the minute before. Might have been the day before, might have been a week before. But it was a pattern of behaviour been going on for some time, and she finally broke down and decided to end her husband's life. So there's got to be a qualifying trigger. The words of behaviour which are so outrageously offensive that it would cause a normal person to lose self-control and to want to kill another. So there's a subjective element about this when a person loses his ability to restrain himself. So there's the loss of self-control. It's straightforward. So Duffy 1949 is about this case. So Lord Devlin, as he later became, he gave a definition of this case, saying the defendant is so subject to passion to make him or her, for the moment, not master of his or her own mind. If the killing is over the top, that in itself doesn't mean that it was a loss of self-control. That's as per a case called Regina against Godwin, 2018. It's the idea of crime passionnel. If you shoot someone once, very carefully aimed between the eyes, probably not a crime of passion. If you empty the gun into the person and carry on shooting even though the person's dead because you were so outraged, then that's maybe more likely that it was a crime of passion. Or in the case of Ellis, when she shot the guy, she emptied her revolver into her boyfriend's abdomen, and she carried on pulling the trigger, snapping several times after the bullets were expended, and just waited there, exhausted, as if in a daze. Okay, so we talked about Ahluwalia before. So even though there was a time lag between the last time she was beaten up and the time she killed her husband, that is still explicable as loss of self-control because the diminution of her self-control was cumulative over several years. Okay, so let me see. There was R against Dawes and Hatter, 2013, and this was a case about a relationship breakup, but the slaying here was considered well in advance, and they felt it wasn't a self-control one because you want your girlfriend or boyfriend to come back and then you're going to kill them. I mean, come on, that's not going to operate. So, what are the qualifying triggers? What does the victim have to do to the defendant to mean that the defendant can rely on this defense of loss of self-control? Well, the Act in Section 55 says where the defendant's loss of self-control was attributable to a thing or things said or done or both, which constituted circumstances of an extremely grave character and which caused the defendant to have a justifiable sense of being seriously wronged. That's the end of the quotation. So it can't be offensive, it can't be very offensive, it's got to be really off the chart for offence. And so the defendant has to rightly feel deeply aggrieved about this. If they call you or whatever a rapist and you really are a rapist, then you don't have a justifiable sense of being deeply wronged. So qualifying triggers. Anyway, so it could be because the defendant fears heavy violence from the victim, or that the victim is going to do heavy violence to somebody else whom the defendant cares about. Okay, there are other contentious cases like Clegg, 1995, that soldier who in Northern Ireland shot dead someone who drove through a checkpoint. He feared he was going to be attacked, but people had gone by, there was no more threat. Clegg carried on firing and was convicted of murder, but I'll come back to the one in greater depth a bit later. Or there is a case called Martin Anthony, 2001, that farmer Tony Martin, who in Norfolk shot dead Barry Fearon, a burglar. Okay, so these were situations when an ordinary person would have felt frightened, and some people say, well, in the heat of the moment he made a split-second decision, probably the wrong decision, but nevertheless shouldn't be found guilty of murder, but they were still found guilty of murder. So anyway, there are pleas of self-defense, but that's a little bit different. The loss of self-control one is somebody did or said something so extraordinarily insulting that an ordinary decent person would just lose his or her temper to such a degree that they would do heavy violence to the victim, which might well end in the victim's death. Okay, self-defense is different. If your self-defense, if that defense works, then that's it. You're not guilty. You walk free. You face no punishment at all. Okay. So let me see. Let's look at other qualifying triggers. So the Act goes on to say, where the defendant's loss of self-control was attributable to a thing or things said or done or both that constituted circumstances of an extremely grave character and caused the defendant to have a justifiable sense of being seriously wronged. End of quotation. So the loss of self-control has to be occasioned by the things which are said and done of an extremely grave character. The loss of self-control can't be because of something else. And the defendant has to have a justifiable sense of being seriously wronged. Being annoyed is not enough. Being jealous because of infidelity or suspected infidelity is insufficient. And as I say, that one is specifically excluded from consideration. Okay, there was a case called Bowyer in 2013 where the defendant who knew the victim was discovered committing a burglary in the victim's flat. So the victim then said something grossly insulting about the defendant's girlfriend. The defendant lost the cool, and then he killed the other person. So anyway, the defense didn't work because the defendant was there as a burglar, and therefore he wasn't justified in thinking that he had been hard done by in what had been said to him. Okay, so let's look at the other limitations on these qualifying triggers. So this is what the Act goes on to say. In determining whether a loss of self-control had a qualifying trigger, the defendant's fear of serious violence is to be distinguished to the extent that it is caused by a thing which the defendant incited to be done or for the purpose of providing excuse for the violence. A sense of being seriously wronged by a thing said or done is, if not justifiable, if the defendant incited the thing to be done or said for the purpose of providing excuse of violence. So the defendant insults the victim insults the defendant back, and the defendant then says, well, he insulted me really badly, so now I can go and kill him. No, you're not allowed to do it if you try that. You get into a slanging match, and then you think the insult just pushed you over the edge, and that now you have a carte blanche to kill the person. That defense shan't operate. So, as I've said before, sexual infidelity or suspicion thereof is inadmissible as a offence like this. So in Clinton, Parker and Evans 2012, it was said that sexual infidelity is not allowed. That's where that was laid down. So Clinton killed his wife because he found out she was getting into bed with another man. But anyway, it was really because then she was going to leave her husband, and she didn't want to look after the children anymore. That's partly what prompted the killing. There's, of course, a case called Dawes and Hatter, which is a little bit similar. So the judge in that Hatter case in 2013, this is what he said. To suggest that the breakup of a relationship could amount to circumstances of an extremely grave character, and that would entitle the aggrieved party to feel a justifiable sense of being seriously wronged, would be to ignore the normal meaning of these words. It would result in the defence of a loss of self-control being left to the jury in almost every case where one partner kills another. Close quotation. That's to say, if anyone, husband, wife, girlfriend, boyfriend, wants to end the relationship, walk away, whether you can kill them and get away with it. Okay, not scot-free, but it wouldn't be murder, only manslaughter, face a much shorter sentence. So that would be just declaring open season on all men and women. Okay, so there's also the objective element, but I think that's enough for today. Might continue with voluntary manslaughter on another occasion. Goodbye.